Hello, Madam will be joining shortly. We will begin within just 2-3 minutes. Thank you.
Madam, good morning. Pradnya Madam, Principal Madam has joined.
Yes, sir. Good morning, Madam. Hello, Madam. Good morning.
Hello, madam. Good morning.
Yes.
Sorry, I was in another program.
Yes, Madam. We know that.
Good morning, ma'am.
Shall
Very
we?
good morning.
Shall we begin, ma'am? Now?
Yes, please, madam.
Yes. Thank you, ma'am. Praful sir, please go ahead.
Okay, Madam. Okay. Hello, everyone. It is my pleasure to extend cheerful welcome to all. As per the tradition of our college, we are starting our program with the national anthem. So I request all dignitaries and participants to stand in honor of national anthem. I request Mr. Mahesh Dudbhate to do the needful and play the audio of national anthem sung by our TYBA philosophy student, Miss Prajakta Shendre. Thank you. Mahesh Dudbhate, sir, can we have the audio of national anthem?
जनगण मन अधिनायक जय हे भारत भाग्य विधाता पंजाब सिंधु गुजरात मराठा द्राविड उत्कल बंगा विंध्य हिमाचल यमुना गंगा उच्छल जलगी तरंगा तव शुभ नामे जागे तब शुभाशिष मागे गाहे तव जय गाथा जनगण मंगलदायक जय हे भारत भाग्य विधाता जय हे जय हे जय हे जय 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 हे.
Thank you so much, everyone. Good morning and a warm welcome to our distinguished resource persons, Dr. Sushma Podwal and Dr. Suvarna Nilak, Honorable Principal Dr. Suchitra Naik, Vice Principals of Degree College Professor Subhash Shinde, Dr. Priyamoda Tokeko, Dr. Mahesh Patil, Librarian Mr. Narayan Barse, IQSC Coordinator Dr. Pradnya Raja Bahadur, all heads of the department, coordinators, teachers and the students. We are indeed privileged to have noted and eminent personalities as a resource person for this online half-day intellectual property right awareness workshop organized by IQAC of our college in association with Department of Business Law, Foundation Course, Research Committee, and Entrepreneur Cell. We are having proud privilege to announce that this workshop is organized under the series activities of celebrating Azadi Ka Amrit Mahotsav to commemorate 75 years of India's independence. We Indians are quick to grasp the modern concept of intellectual property right. I remember an impressive opening speech delivered by Mr. Maharaj Krishan Kaur, then the Secretary of Department of Secondary and Higher Education under the Ministry of Human Resource Development, Government of India, regarding the importance of intellectual property rights, in which he said, "We talk of going back to nature these days. India believes in harmonious existence with nature all through its civilizational existence. Ayurveda today is recognized as a comprehensive system of medicine which organically heals the body. In the field of science, contribution of ancient sages like the Bhaskara and the Aryabhatta are immense. Aryabhatta had proved the existence of solar system many centuries before modern science knew it. The Indian epics of the Ramayana and Mahabharata are creation which survived thousands of years through oral and written tradition, maintaining their purity over millennia. The paintings which adorn the walls of the caves of Ajanta and the Ellora, painted hundreds of years back by Buddhist monks, are still being appreciated even today. The artistic works of magnificent temples and the world-renowned monument like Taj Mahal are tributes to Indian creativity. Even the folk tunes and the designs which our communities develop and the preserve, passed down from generation to generation, stands testimony to the creativity of Indian people. India, over millennia, always encouraged creativity and innovation with its own systems of fostering creativity. The enlightened rulers of ancient or medieval India took intellectuals in various fields to their courts and gave them royal protection and encouragement. From the Navratnas in the court of Vikramaditya to the court of Akbar the Great, such protection only symbolized the importance this country attached to fostering intellectual pursuits. So with this note, this workshop aims to create awareness and understanding the issues relating to the IPR, especially patent, plagiarism, copyright, trademark, and the geographical indications. The objective of this workshop is to disseminate information regarding intellectual property rights among the faculty members, researchers, and the students, and take them from eons of scarcity to the era of abundance. We hope that you all will go back at the end of this the workshop intellectually enriched and stimulated by standard operating procedures related with the patent, copyright, plagiarism, and the trademarks by the meticulously arrangement of the two sessions for this workshop. Session 1 is the plagiarism, a right copied wrongly, will be engaged by Dr. Sushma Podwal, Madam, retired librarian, SNDT Women's University. And session number 2 is the recent judicial trends in copyright and trademark, which will be engaged by Dr. Suvarna Nilak, Associate Professor, ILS Law College, Pune. So now I would like to invite a person who is constantly dedicated to keep us updated and informed, especially during these rapidly changing times. Yes, ladies and gentlemen, Dr. Pradnya Raje Bahadur, IQAC coordinator, to talk about the program. Yes, Pradnya madam.
Yes, thank you, sir.
Yeah.
Good morning. And sir, you made my task very easy by elaborating about our workshop, theme of our workshop. Thank you. Good morning once again, respected Principal Madam, Dr. Suchitra Naik, today's resource person, Dr. Sushma Podwal and Dr. Suvarna Nilak, Madam, Vice Principal, Subhash Shinde, sir, Dr. Tokekar, Madam, Dr. Mahesh Patil, sir, all the HODs and coordinators, administrative staff, my teacher colleagues, and my dear students. I welcome you all once again on behalf of IQAC Joshi Bedekar College, Department of Business Law Foundation Course, Research Committee, and ECEL in this IPR awareness workshop. At the outset, I place on record my sincere thanks for the support and encouragement from our management, that is Vidya Prasarak Mandal, and our principal madam for organizing such activities. This year, when the nation is celebrating Azadi Ka Amrit Mahotsav, Joshi Bedekar College has also decided to organize such activities based on the theme as a mark of respect. And this IPR workshop is also one of the activity in the series, taking the note of the technological development in the contemporary era. Looking the existing scenario, the technological world, to protect the intellectual property and related rights in this technological development will be a tough and demanding task. Therefore, government has also announced National Intellectual Property Awareness Mission under the tag of Azadi Ka Amrit Mahotsav. At Joshi Bedekar College, this is the 4th year we are organizing IPR awareness programs. We have organized programs on the topics like emerging trends of IPR, as well as evolution of IPR. And this year, we will be discussing the concept plagiarism, which goes against the copyright if right is copied wrongly. Plagiarism becomes very easy with the technological development, but with the same technological development, we can identify the plagiarism percentage. Dr. Paudwal madam will be the right person and she will throw light on the issues. I thank madam for accepting our invite, and she is also our member of our research committee. And thank you, madam, for joining us. Secondly, we will be discussing judicial interpretation of copyright and trademark. As it is rightly said, judiciary puts the flesh and blood in the black letter of law when it interprets the provisions of the law. Thus, understanding the law will be better when we understand the judicial interpretations of the provisions. And this will be explained by Dr. Neelakh madam. As Praful sir has already stated, she is the assistant professor in ILS Law College, Pune. I thank madam for accepting our invitation. Welcome, madam. And I'm sure listening to both these personalities, experts, we will be enriched and it will be an enlightening experience for all of us. I appreciate the efforts of all the associated department and committee members as well as chairpersons for executing this program. I once again welcome you all on behalf of IQSC and associated departments and committees for this Jnana Yajna. And I will conclude with a Sanskrit shlok. Nasti vidya samo bandhur, nasti vidya samo surud, nasti vidya samam vittam, nasti vidya samam sukham. There is no friend, no company, no wealth or no bliss as vidya, that is knowledge. So let's resolve to create, respect and protect intellect. Thank you for patient hearing. Thank you.
Thank you so much, Claire Pradya madam. It is a matter of great pleasure and honor to invite a person who is having great ideology, determinism and clear vision. Under her leadership and guidance, may we reach the next level of glory. Yes, I'm talking about our beloved principal, Dr. Suchitra Naik. I request Madam Principal to bless us. Madam Principal.
Good morning, one and all. Today's distinguished guests, Dr. Sushma Paudwal and Dr. Suvarna Neelakh. At the very outset, I would like to thank you for joining with us. I congratulate IQAC Pradnya Madam for taking this initiative and continuing this initiative and joining students' project with this activity. Secondly, I appreciate Praful's efforts to take a cursory look at the concerned topic. And today we are going to talk about plagiarism and judicial threats in copyright and trademark. I'm sure all teachers and students are waiting to listen from both the distinguished experts. But as Einstein has said, creativity is fun, intelligence has. Okay, so we all are intelligent, we all are rational beings. So as early we understand, as early as possible, students realize what is fun and excitement in creativity, of course, which comes after. I mean, if I excuse myself for over exemplification, but which follows after dark night of soul, what we get is excitement. And if we learn the enjoyment, this intellectual joy, I think that itself would be a lesson against plagiarism. But unfortunately, maybe due to large numbers, maybe changed system of education, we are not able to create these moments of joy and excitement. I would here like to put on record Sushma Madam's, unconditional support, which our institute has been getting for pretty long time. Though I have hardly got opportunity to interact with her in person, here I would like to speak something in Marathi. एकदम मराठीत मला एक उपमा सुचते की जसा सुगरणीचा हात फिरल्यावर स्वयंपाकघर सुरेख व्हायला लागतं, तशा पद्धतीने आपल्या रिसर्च ऍक्टिव्हिटी मध्ये, मग ते कोर्स वर्क असेल किंवा आपलं एथिक्स कमिटी असेल किंवा प्लेगिअरिझम चेक करणं असेल, सुषमा मॅडम फार सुंदररित्या त्या मितभाषी आहेत, पण अतिशय चोखपणे त्या काम करून शी हॅज ऑलवेज बीन कॉन्ट्रीब्युटिंग. आय नो she has very great legacy. She is taking it ahead. And so, Sushma Madam, thank you very much for that. But my effort is to make us all feel that excitement of creativity, that joy of creation, which is great antidote against plagiarism. And of course, everything else follows, which is equally important. I'm pretty aware of it. So, as Pradnya Madam very correctly said, law is it's black and white letters. To bring justice, to catch justice in that, or to take any effort, the idea converted into business, business converted into, actually situated in lifescape. This is a process, this is a journey where, we need protection through maybe trademarking, we need protection through copyright when it comes to, again, creative writing, so on and so forth. Of course, I'm not expert in all this, but again, here I feel, expert like Suvarna Madam can definitely tell us and our students who are going to take up some small startup business adventures, how, trademark can help them in protecting their ideas, in protecting their business. With these words, I once again greet all my colleagues, all my friends who are present over here, teacher colleagues, looking forward to rise many trademarks from Joshi Bedekar College. All my 500 students have already joined. I'm very happy with the number. I'm sure they are very much interested in both these topics. I appreciate all these students, and once again, I thank this distinguished guest for joining with us. Thank you very much. Have a nice day.
Thank you so much, madam. With your blessing, you have invigorated our spirit, and your enlightening words inspire us. So with this program, definitely clear that we are going to make indelible memories. So I request all dignitaries as well as clear the participant to turn on your cameras to take some photos. Bhakti madam, please do the needful and let us know once you click the photo.
So just give me 1 minute. There seems to be some network connection, network problem.
Okay.
Is it done, madam?
Madam, someone else can do the needful. I'll tell our committee over
Yes.
here. Just a minute.
Supriya, madam, or otherwise, I will.
Avinash sir.
Hello. Yes, ma'am. Hello.
Is it done?
Madam, I'll call technical team. Just a minute, huh?
Yes, ma'am. Done.
Yes, it's done. It's done.
Okay.
Thank you.
Thank you.
Thank you, madam.
Thank you so much, Clear Bhakti madam. Now I request Dr. Jhanna Tolani madam to introduce our guest of session 1, Dr. Sushma Podwal madam. Jharna madam.
Thank you, Praful sir. It is indeed our honor to have Dr. Ms. Sushma Podwal as our guest speaker for the lecture on plagiarism, a right copied wrongly. Dr. Sushma Podwal is retired university librarian and head SHPT School of Library Science, SNDT Women's University. Ma'am is a doctorate in library science, recipient of H.D. Wellinkar Veda Prize for Sanskrit in her MA examination. Ma'am have a rich experience of 8 years with SNDT Women's University, 14 years of earlier experience with Lala Rajpat Rai College, 13 years as Deputy Librarian, SNDT Women's University Branch Library, Juhu, Mumbai. Ma'am has teaching experience of 25 years and recognized guide for research in library science. Ma'am has organized various seminars and training courses, refresher courses, and research methodology pre-PhD course at SNDT University for library staff, research scholars at different levels. Ma'am has published various research papers and books. Dr. Podwal has contributed to various professional journals and was on editorial board for 2 international peer-reviewed journals and has written articles on different aspects of library management. Ma'am has undertaken UGC minor research project on cookbooks as tasty samplers of history. Ma'am has visited various countries for attending and representing India at international seminars and conferences. Ma'am, it is our honor to have you today with us. Now, I request Dr. Podwal ma'am to start with the session. Over to you, Sushma ma'am.
Are the rights given to me so that I can start with the PPT?
Yes, madam.
Are the rights shared? I am co-host. No?
Yeah.
Okay. 1 minute, please. Is my screen shared? No, no,
No, madam, no,
not yet, no?
not yet. Yes, it is not visible.
Okay. Please wait. Yeah. Is it visible now?
Yes, madam, yes.
Yeah.
Okay.
Okay, okay. Thank you. Now, thank you very much, Janna madam, for my elaborate introduction. At the outset, I thank Dr. Suchitra Naik, principal of this college, and congratulate her, of course, for having a program under IQAC like Azadi Ka Amrut Mahotsav, and under this having a workshop, elaborate workshop on IPR, intellectual property rights, and giving me an opportunity to speak on a delicate topic like plagiarism. Right copied wrongly. Let us see which are the stumbling blocks in research. I also thank Dr. Jayashree Singh, madam, and the IQAC coordinators, Dr. Pradnya Raje Bahadur, and other coordinators also for inviting me to talk to you on a topic like this. Now let us turn to the topic itself. There are two sides of the coin of plagiarism, or IPR, we should say. One is that we all should understand the concept of intellectual property. What is intellectual property? Which we are going to deal with later. And I think the next speaker will definitely deal with the niceties or integrities of the topic. I will be just touching on the ethical side. She will be touching on the legal side. So one part is ethical, other part is legal. When we say plagiarism, many a times it may be that unknowingly students many a times copy and paste the things which is not right. And this may be due to various reasons also. Let us turn to the topic. These are two sides of the coin. One is from researcher's point of view. From researcher's point of view, it is our original research. So whatever data you are collecting is primary data. The researcher is doing research and bringing out primary data. This data will be then shared to the InflibNet. You are going to give it to the InflibNet and the whole world will be sharing this data. Now, from researcher's point of view, if somebody else picks up your data, or if somebody else picks up all the words, the way you have elaborated your theory or why you are doing research, and if somebody uses them in their own research, what will happen? You will definitely object. So it is from the researcher's point of view, you are giving birth to original data. So it is your original research. The other side also we have to think of is when we are researchers, we are using other person's works. We are using the books or internet-based data, whatever data we receive, in literature review also, we review the literature and books, journal articles we use databases, and we take the information from those resources. When we take the information from these resources, we always have to be careful to protect the right of the original author, because after research, you are also going to become an original author. You will get offended if somebody uses your material. So using the material by cognizing the death of that author is the right way to do that. So if you don't cognize, if you don't quote that person, it will be injustice. It will be unethical on the part of research also, and so this is ethical side of research, which I am going to explain you to.
Madam, Paudwal,
Yes.
madam, can I interrupt?
Yes.
Sorry,
Yes.
madam, we are not able to see your screen. That is your PPTs. We are not able to see on the screen.
Okay. That only I asked you. So I thought.
Your screen is
minute,
visible,
huh?
but PPTs are not running.
Okay. Now, can you see? Is it visible?
Not yet, madam. Not yet.
Not yet.
Yeah.
Okay. See?
Yes, ma'am.
Is it visible?
Yes,
Yeah.
ma'am.
Okay.
Thank you so much. Ma'am.
Okay. Now, the term plagiarism is derived from Latin plagiaris. It means a person kidnapping slaves and children. It is an unethical lapse, and as I told you, both ethical and legal sides are there. We are going to consider more on ethical side. It is considered to be academic dishonesty, which might infringe on copyright of other people or the original author. Now, another very important concept that has to be understood is consent. So when it is called informed consent, when we do research, we have to take the consent of the participants, or we have to take the consent of those with whom we are working, isn't it? Sorry. So informed consent it is necessary because you take the consent of the participant. And what should be included in this informed consent? So this concept also has to be understood. You have to describe the nature of your research to the participants. Then there should be a statement that your research is voluntary. And this is also very important, that participants can leave your research, they can withdraw from your research anytime. And that statement also should be included in such letter, covering letter. Then you have to identify if there are any risks or if there are any benefits that the researchers will get. For example, a person who was doing research on single parenting, the person said that I will be preparing a guide for single parents and you will be getting the benefit of sharing that guide. So I will be giving you that guide. So such things also need to be described. What benefits you are giving and what risks they will be taking. If you are performing some type of research problems, if you are discussing or brainstorming sessions, or you are taking up some sessions or experiments are conducted, you have to explain the involved risk in such experiments. Then you have to describe of how the confidentiality of those persons will be protected. This also has to be shown. 1 minute, I'll do the slideshow again so that you can see the slides completely. So you have to describe how their confidentiality will be protected, and it needs to be protected. Then description of what information researcher will share with the participants. That also you have to explain. And identification of who is responsible for research and your contact information needs to be given. So these are all important things, which is called informed consent in the beginning document or the letter that is covered. Now, this plagiarism is considered to be a research misconduct. It is called as research misconduct. So it has basically to do with the research misconduct, and hence there are three types of misconducts. Some people include fabrication and falsification under plagiarism itself. One is fabrication. This means you totally alter the field data of somebody else or outcomes of somebody else. You completely change that and take somebody else's data or alter that or regenerate the data. You take an idea from them and regenerate the data. Falsification means you change the data. So manipulate the data to suit your own objective, and then accordingly you use that data for your own so it is also false data, using false data. So that is falsification. And then plagiarism. Plagiarism is using other person's ideas, results, or words without giving due credit to that person. Now, fabrication. It comes from Latin word fabricatinum. It is nominate of fabricatio, meaning a structure, construction, or making. This is second most form of plagiarism. So some people bring it under plagiarism itself. So here, false invention of data and outcome is done. New records are created out of the data and results, or even results are newly created, and such experiment is not conducted at all. It is just fabricated. This is most commonly fabricated are forms of consent of the people. So wrong names are given, new names are given of the participants, and patient diaries. Many a times in medical or in experimental research, diaries of peoples are reconstructed and then presented as collected data. Then photoshopping of images. Many a times the images are made to suit the background of your own research. So nowadays photoshopping can be done. I share one of the experiences. I had gone as an evaluator of small research. It was master's level research, and I found that the photographs of my own library at Juhu, I was working as deputy librarian at that time of SNDT University, and I found that these photographs were used for the research, saying that this is a library from Ulhasnagar, and this library was flood stricken, and the new library, the new image of the library is like this. Since it was my library, I could recognize. But people can use the different background and say that this is our library. So this is fabrication of data or fabrication of the photographs. Such things are really objectionable. So do not do this, because this is wrong and false things. Now, exactly falsification. Under plagiarism, falsification also people are saying this. It is most common form of plagiarism. Here, research processes, materials, equipment are manipulated, just changed. Instead of saying that I use this, the researcher used this, only the experiment is changed, showing is changed, and the idea is taken up from the other person's research. Then the research in the research record is not accurately represented. because you yourself have not done it. So it is shown as other person's research, and you just change some of the data and present it. Or presenting false transcripts. When qualitative research is done, interviewer keeps exact transcripts of research, whatever is asked and the answers that are given. So these transcripts are presented falsely, changed and falsely presented. Now, the difference between fabrication and falsification. Fabrication is saying that data is existing when it doesn't exist at all. And falsification is you change the data. In fabrication, you are creating imaginary respondents. Their names are changed and imaginary respondents can be taken up. In a survey, that is fabrication. And in falsification, you change the answers from real respondents in a survey, suiting your own objectives, that is falsification. So there is difference. In fabrication, you recreate the data. In falsification, you just change, there are minor changes, and then you produce the data as your own. Plagiarism actually is using someone else's written data, theory, or opinion to use material without crediting the source. Whenever you write anything, may it be literature review, you have to have citations. You have to give quotations of the original work which you are using. When that is not done, it is plagiarism. It can be called as without crediting the source. It can be written data. It can be data from internet. It can be music, drawings, design, anybody's dance if you are reproducing, photography, and other artistic and technical work created by someone else. You are showing as your own. It can be reproduction of tables, graphs, any other graphic material, graphic element produced by someone else without giving credit. So one important point here is all the students should give credit to the original author by writing the surname of the head. And at the end, you have bibliography or citations. So all citations should be given in your research. So you cognize, so that you cognize the death of the original author. It is covered under plagiarism. You can even paraphrase the things and give. It can be a summary. So it can be unattributed paraphrase without recognizing somebody's death. Or it can be summary of someone else's spoken or written words. It can also be the lecture. You are taking up the lecture and then reproducing them. Then contribution of ideas by others with whom you have collaborated. There is collaboration and collaborated work is there. And only one author uses it as his or her own work. That is also plagiarism, because whenever you are using that work wherein you have collaborated with others, even the co-authors should be recognized. So without recognizing them, so that will also will be covered under plagiarism. You will say, oh, I am one of the authors, so why not? It is my work, so that paragraph is written by me, so what? But the whole work is contributed to all the co-authors also. So you have to recognize the death of the co-authors. So give the names of all the authors. So contributions of ideas by others with whom you have collaborated. Cutting and pasting from internet. This is very objectionable. Without giving the reference or without quoting it, just cut and paste. This is possible nowadays, and doing that, many people are attracted to this, or many times you do not have language skills. That is why you may resort to such ideas. Please don't do that, because it will fall under plagiarism. Then machine downloading from database. This is very objectionable. There are students, research students, whose friends are in very good institutions like IIM, IITs. And those students from IITs, they have machine downloadable software. Or such students normally have machine loadable software. So machine loadable databases, if you take up a database and with that software you download something, it is very fast and it can be detected and recognized by the database owners. So this is again a very bad, ethically very wrong practice. And such students don't know. One thing had happened 2-3 years ago that the student was not aware of this. He downloaded so many things for his own work and then he committed suicide. So they think it is not, many of the students do think that downloading mechanically is not hey at all. But these database vendors have your addresses also. So please keep in mind that machine downloading from database also is objectionable from plagiarism point of view. And it is this thing will come under law. So it is illegal. Then there are salami publications, which we are going to see. What are salami publications? So that is that is called self-plagiarism. That is, you plagiarize or you use your own work at 2-3 places. So that is salami publications. Now, types of plagiarism. Sometimes it is unintentional lapse. You are not aware, and that is why you just take up certain things and use them. Then it can be unintentional and accidental. Now, what happens? While taking the notes, you have to be very careful. What I advise every time, you keep a card. I'll show you. This type of cards are available with pastiwalas or with the shops also. You will get such cards, stationery shops. Take up such cards and then on these cards, write down the resources which you are using. At the back of the card, write down the para which you are going to use it or which you are going to quote, and then write the page number also, so that you need not go to the library again and again to find out which sources you refer to. So if you do that, then unintentional or accidental plagiarism does not take place, because many a times students do what? While taking the notes, they just write the para. They don't take the page number. They don't take the sources properly. And next time they go to the library, the book is issued out. So many a times they come across with accidental plagiarism. Please do not do that. Then self-plagiarism, while using your own work, you have to cognize your own debt also. So this is called self-plagiarism. When you are using your own words or your own paragraph from your own article, still you have to give, that is called self-quotation. That is called self-citation. Self-citation. So self-citation also should be there. But here, what problem you face? There is something called as H-index. And in H-index, you see how many citations are given on your name. So H-index captures research output based on the total number of publications and the total number of citations to your works. Now, UGC has objected on self-plagiarism, and UGC in, I think, April 2020 has come out with a circular saying that self-plagiarism will not be taken under H-index. If you have to take out H-index, if you are quoting yourself again and again, that will be taken out, and then you have to count on the H-index. So this is very important. This is now objectionable. You cannot use your own research at 100 places. But of course, I always tell that to my students, you are supposed to generate 4 documents or 2 documents or 3 documents, whatever university tells you, out of your own research. For that, self citations are permitted. And because you are doing one work on your research, and out of that one work, you are using, that is called salami slicing. But since that is a condition of the university, you have to follow it. Then mosaic plagiarism. Here what is done is you use different sources and like a mosaic tile. So different sources you patch up. So it is like patchwork. And then you use all this, that is mosaic plagiarism. Direct plagiarism, that is verbatim. As it is, you take the material and use it. Sometimes you paraphrase it, but sometimes you don't paraphrase. Now, other types of plagiarism, ghostwriting. Many researchers use ghostwriters. Different writers are made to, but this is also objectionable in research. This is also unethical in research. But if ghostwriting is done, even the ghostwriters are responsible for plagiarism. Patchwork. Patchwork is like mosaic only. You take up different patches from different hay and do it. But literature review is out of that, because in literature review, you are mentioning the source and then it is like patchwork only, that whole chapter. Then complete plagiarism. Completely, you take up the research work of other person, just change the names and use it. So complete, near complete, more than half of it is completed, completely taken. And self-plagiarism, of course, we have seen that. These are other types of plagiarism. Now, some other types is clone. Now, clone are, it is an act of submitting other person's work, word for word, as one's own. That is called cloning. You say that it's my own, but you are submitting other person's work wholly. Then Control C. A written piece that contains significant portion of the text from a single source without any alteration is Control C. Control C and Control V, isn't it? So find and replace. There are different types of copying. One of them is find and replace. Find is finding and changing the most common keywords and phrases that are copied content. In the copied content, you just replace some of the keywords so that it doesn't look like plagiarism. Then remix. This is collecting information. Remix is collecting information from different sources and mixing it all together. Then recycling it. Recycling is self-plagiarism. Borrowing from one's own document without proper citation and use it again and again and again and again for different things. Then hybrid citation. Hybrid citation is you perfectly cite the source, okay, but sometimes mix it. Then mashup. Document is copied from more than one sources and mixing together is done without any citation. This is called mashup. Now, ghostwriting and patchwork plagiarism. Ghostwriting is somebody else is writing on your behalf. You have given the writing work, you have outsourced it without acknowledging the source. Then patchwork plagiarism is mosaic plagiarism. Text from various sources is used without acknowledging or giving the credit to the author. Now, complete or near complete. When the author copies another work whole wholly word to word, it is complete. And if substantial portion of the original text, more than 1/3 is taken up, is copied without acknowledgement, it is near complete plagiarism. Now, self-plagiarism, republishing your own work without giving reference, this we have already seen. Taking out portion of your own written work and including the same in other work without referencing the same. So give self-citation at least. And third is using previously written or published work without crediting the source. Reusing previously written, you have written and you have published it, so you are reusing the thing. Now, in this regard, there is UGC circular dated 20th April 2020, saying that such self-plagiarized things will not be taken up for promotions or for H index. They will be deleted. Now, who is responsible? Authorship is another important area which we should take into account. So when we say that there is somebody has plagiarized, who is the author? That is the question that comes up. Always that will be considered. Who is responsible for doing this? So you have to define the authorship. When we start defining the authorship, we will see that all the authors, co-authors, first author, and all the other authors are responsible for that. Even those whose name may not have come, but those who are responsible for getting the data, those who are responsible for correcting. For example, many a times, in case of colleges, principal doesn't write, or the person from management doesn't write the article, but that person's name needs to be included because you have taken grant from certain source. So this grant tells you that the name of the institution's head should come as a writer of the article. In such case, principal also is responsible, or such person also is responsible. So this is public responsibility for defending the paper of the paper for content, data, or for its interpretation. Those who are responsible for this will come under the authorship. So it is very important to see. Many of the peer-reviewed journals give you conditions for authors, or how to write an article. So how to give citations. First study that and then only submit your own work. So honest, transparent writings, they generate trust of the public. And that is why authorship is very important. When you plagiarize something, your name as an author gets in trouble. Even publishers, editors, in case of publication in journals, editors, peer reviewers, or sponsors who have given money, sponsors institutions also are responsible for the public. And that is why if the legal from the legal point of view, all of them come under the will come under inspection. So ghost authors and also the gift authors. So many a times money is given and they may not have contributed, they may have contributed, but now gift authors are authors who have not contributed, but are added for name's sake to obtain funding. To obtain funding, their name is included. Such authors, or they are called gift authors, they are also responsible if something happens or if plagiarism is detected. Now, who is the author? That is accountability. The person who has done substantial contribution to concept and design. So illustrators also will come under it. Acquisition of data and analysis and interpretation of data. For example, many of the researchers get the data analyzed through somebody else, like statisticians do that work. They are, if something wrong happens, and if that goes to court, they are also responsible. Those who are doing analysis and interpret, even ethically, they are also responsible because they have analyzed and interpreted the data. Of course, interpretation can be done by the researcher, but who analyzed it and how it analyzed it, that comes to the analyzers also. Their name may not come in the authorship, but they are authors. Their accountability is taken into consideration. Those who are responsible for drafting the article or revising it critically for important intellectual contents, they also are responsible or accountable. Then final approval of the version to be pursued. Who gives the final? If it is main editor, chief editor, the chief editor also is responsible, and they should take the responsibility of errors and omissions. And then what is done is, if that is found later on, then the article is retracted. It is retracted or taken back. Reasons why it is done. Why we adopt to plagiarism? Pressures of study. Please do not do that. If you are pressurized, start doing systematic work right from the beginning in research. As a guide, I always advise my students that there are some period of time when you don't feel like working on your project. Don't work. Or don't just try to take somebody else's under pressure of the study. Don't take up psychological pressure at all. And as Naik Madam has already told us all, that it should be really a great fun. The research is a great fun if you do it methodically. For getting API scores for promotion, for this reason also people start resorting to plagiarism. Diversity and availability of resource material in open access. Nowadays, in open access, you get everything. PPTs on all the topics, everything, the information that is under open access is freely available. And that is why you feel like taking that. But see what type of licensing it has got. Just observe that. Then lack of guidance, wrong priorities, lack of time. Lack of time management, I always call it, not lack of time. They hurry up and they do not do time management right from the beginning, because you have 3 to 6 years. What are you doing as a researcher? Then lack of language skills. Now, for such things, the software like Grammarly will help you. Lack of patience, this also should be avoided by the students. Now, steps to avoid plagiarism. First, we should try understanding what is plagiarism. What is plagiarism? Then make use of proper citations and learn how to cite. Then paraphrase properly. Then there are also software which give you paraphrasing. We are going to see that. Present your own idea as far as possible. Try to do that. Now, salami publications. This concept it was actually very new for me also. Like salami slices, this term is used very ironically and in a derogatory way to show inflated number of publications. This comes under self-plagiarism. It is defined as publication of 2 or more articles derived from a single study. One study, and you derive so many articles from them, taking same data and using it. Then sending parts of research to different journals for publication. This is called salami slicing. But according to me, if the university tells you to publish articles based on your research, there is no help sending parts of research to different journals. But then use self-citations so that you are not at fault. Reasons for salami publication. To increase reputation, people do that. Then To increase publication count, many a times it is done. For faster career progress, we want that more articles are published, and for that we do. For more funding. Now, if you see this, I have given reference from this slide share. I have used the matter of salami publication. So even if you are giving a lecture, it is necessary to give credit to the matter which is licensing. And I have also given, wherever I have used the images, the references are given at the end. So it should be done. Researchers use other person's work to apply model or a theory, to analyze the point, to criticize on the other person's works, to summarize the point that other authors has given, and to quote. When you use research other authors' works for doing all these things. So see for what you are using it, and then this can be avoided. Plagiarism can be avoided. Now, researchers quote to support their argument. So quotations are used for supporting your argument, to disagree with the author, to highlight thoughts, to compare opinions of two or more authors. For such things, use quotations so that it is not, you are not taking up anybody else's, okay, and it is not plagiarism. To emphasize importance of earlier research. For doing this, you are using quotations, but give, so that should be citations. After write quotation mark, give that para in quotation marks, and then cite the author to avoid plagiarism. For paraphrasing and summary, expressing other person's ideas in your own words. For this, it also needs citation. You are using your own words, correct? But these are other person's ideas. So give citation of what you are, from the source you are getting it. Summary is shortened version of the original text. For summarizing also, you use other person's ideas or other person's thing. Use quotations, use citations. Now, where the citations should not be used? For example, whatever is common knowledge. For example, whatever is the news. Now, yesterday, famous actor Ramesh Dev expired yesterday. Now, this is a news, isn't it? You need not give the quotation for that. Or man, child is a, whatever you quotations you use, child is the father of man by Shakespeare. So for such things, you need not give the reference to quotation dictionary. No need, because this is common knowledge which can be used. And there is no question here about you are copying somebody else, because this is given to the society free of charge. You need not cognize these things. Say, you can say that according to Shakespeare, but you need not give the source and save yourself. That is not plagiarism at all. So what should be done? What should be the approach? Before submission to any authorities, screen your work properly. Think to yourself whether I have taken notes properly. Be careful at every stage of research and keep records. Keep your questionnaires. Then everything should be kept for Viva. All these records, then whatever notes you have taken, keep the record. Then even the references taken, libraries used, keep record of that. Organizations, individual authors, and journal editors should take care and adopt preventive measures using plagiarism detection software. And that is done nowadays. If you give an article or submit an article for publication, the editors do use it is practice with the journal editors to use the plagiarism detection software. So they judge your article on the basis of such things. For universities nowadays, you know that it is mandatory to attach certificate giving percentage of plagiarism, whatever it comes to, using the checkers. There are plagiarism checkers. So there are free software as well as charged software. Let us see which are free software available on internet. DupliChecker, Plagiarism Checker, Plagiarisma, PlaxScan. These are some of them. There are so many else. Now, Urkund is a software which is given by Inflibnet to the universities who have signed the MOU for giving their thesis. Now, paid software, Turnitin, Scriber, Qtex. These are some of the paid software which are purchased by the colleges. Now, other measures. Other recommended measures by UGC are establishment of ethics committee by the universities, guidance sessions for researchers, for example, workshop like this, avoiding machine downloading, and inculcating atmosphere of honesty, integrity, and ethical use of information. Here, librarians are very good guides. My last slide will be on that. We will see how they also help. Now, punishments for plagiarism. Academically, expulsion from the course and failure from the course. At institutional level, they fail you from the course if plagiarism is checked. At institutional level, blocking promotion or dismissal from the post. If legally it is punishable, then substantial fine or imprisonment also is there. Retraction from publication, if at all the journal takes up and publishes the thing, it is retracted if such thing is detected. So, if plagiarism is detected, then retraction from publication is then action taken up. Publisher banning the access to the databases if gross download is done. Then material not be accepted for publication for year specified. For year specified, this is also done. Then dismissal from faculty position. There can be job loss. You may lose your job if it is very serious thing. And rejection from research grant. You will not get the grant. Now, consequences. What should be done? Many a times, counseling and advice. You need counseling, just take counseling from the experts. Then you are given low grade, very low grade, that is done for the students. Then suspension or expulsion, that is the consequence. Disciplinary action is taken, it can be taken, please keep in mind. Your reputation is at okay. So it is damaged and lawsuit can take place. Indian scene. There is Indian Copyright Act in 1957. It was passed. Now this will be elaborated more by the next speaker, so I will not take that much time. But there is fair use doctrine, which says that certain amount of use of material can be done for research, can be taken up for research. And for that, you can use that material. You can get Xerox of that material. Normally, libraries allow up to 1/3 of the whole document for. So there is fair use. This is fair use doctrine. Certain amount of information can be taken up. Then and can be used. For example, if I want to show here some presentation by somebody else on the internet, if it doesn't have copyright, I can use it in this seminar, workshop. But if it has got copyright, I can use the name and I can also show it without taking permission for a limited viewers and researchers, if they are researchers. So this will be for your own study. You can use that. Now, according to UGC Act in 1956, section 26, there has been a regulation in 2009, which has got indirect effect on plagiarism. So UGC also has taken up this matter. And later on, this matter was also taken up very seriously by UGC from 2018 onwards. Then 300 plus universities have signed MOU with InflibNet that they will give their research on Shodha Ganga. And plagiarism policies are passed by many universities, IITs, universities like Gujarat University, JNU, Savitribai Phule Vidyapeeth. They have passed the policies on plagiarism. Then 34,000 plus PhDs get recognized every year in India. And that is why UGC has prepared a document regulation of 2018. In 2018, they found that there has been a crop of predatory journals. Predatory journals are the journals who have been taking money from the authors and publishing. Or there were small colleges who were publishing their research. And where they have also found that the research that was reported was not reported properly, taking care of plagiarism. Under an Indian Copyright Act, any of the writers, they are saved with the copyright. They are having a copyright. Their work is having copyright for lifetime of the author plus 60 years. So till that time, for example, now Rabindranath Tagore's works are out in the domain, public domain, or Shakespeare's works are out in the public domain. So till the life of the author plus 60 years, you cannot use that material. So it will be liable for legal punishment. So it is infringement, that is imprisonment for 6 months to 3 years with a fine of rupees 50,000 or 2 lakhs as per the percentage. And there is a copyright board for the resolution of disputes. I touched upon a doctrine of fair use. You can use some part. Then permission for selective copying and distribution is given under fair use clause. Now, this is very important for us. There is UGC document, and it is there is a regulation of 2018 which gives anti-plagiarism norms. They say that there are 4 levels of content similarities. First level, 0 to 10% does not have any punishment. 2 level, 10 to 40% of content similarity, the manuscript will return. Third, return, and annual increment will be blocked for 1 year. Level 4, 60% plus content similarity, manuscript will be returned, annual increment will be blocked for 1 year, and candidate will not be allowed to guide research even at master's degree level. Now, for repeated incidences, there can be suspension or removal from job. These are the punishments. Now, under Urkund software, there is color indication. For no plagiarism document, you have to give it for Urkund nowadays before submission. Before submission, your thesis will go to that department. You'll have to send with InflibNet. So for no plagiarism, green signal will be given. Level 2, 10 to 40, orange color will come. And level 3, 40 to 60, red color will come. So you have to be careful. And there also is where matching text is shown. Many a times, some portions are such, or some words or some phrases are such, we can be said to be matching. For example, in spite of that, or for example. So some phrases can be repeated in any documents. So such things can be omitted and like they have knowledge of how to lessen with the proximity. These are called proximity searches or proximity matches. So proximity matches can be deleted. Now copyright versus plagiarism. Copyright protects the right copyright holder. As against this, plagiarism deals with. Acha, 1 minute. Huh? I'll just try. 1 minute. Huh? Please hold on for a minute. Baba? Am I audible now?
Yes, madam.
Hello?
Yeah. Yes.
Am I audible?
Yes, madam.
Yes. So copyright protects the right of the creator of the publication or copyright holder, whereas plagiarism deals with violation of ethical norms. It is more ethical regarding licensed and unlicensed publications. Plagiarism is more of an ethical situation than legal one. Now, concept of intellectual property. Any work, any research work is considered to be creation of intellect or even book, published work, and that has got commercial value. So nobody should be commercially affected. This is the concept. So literary works and publications, patents, GI, trademarks, all these will come under they are intellectual properties. They should be protected also ethically as well as legally. Then there is copyright protection and fair use clause, which should be taken into account. This is all about intellectual property. Now, this has been taken into account by UGC, and UGC has come out in 2020, a document about expectations from research students, which is really an eye-opener. Am I audible?
Yes, madam.
Hello?
Yes,
Am I
ma'am.
audible?
Yes, you are audible, madam. Yeah.
Am I audible now?
Yes, madam.
So UGC has come out with a document of expectations. They say that you should know what it means to be a scholar in good standing with respect to rules and regulations of an institution. Be systematic, and means the student should be systematic and rigorous in the conduct of research. They should carefully plan and execute research protocols that are given by UGC and follow safety procedures. continued, huh? That is. Hello?
Yes, madam.
1 minute. Huh. Now, research students, they should diligently maintain accurate research records like questionnaire, Google Forms, etc. They should seek advice of senior faculty or researchers regarding ethical questions and practices. They should disseminate findings in a timely manner in appropriate outlets. And they should present findings in an ethical, unbiased manner. So these are the expectations of UGC. So this will come under academic integrity. When we copy, we cheat ourselves. So keep this in mind. So there should be a sense of guilt that comes inside our mind. It is right to give credit to the author whose ideas we use. And it is also their right, which is copyright. So we think that it is our right. No, but it is their right. And that is why we should give credit to their ideas. Citing gives authority to the information presented. So your own information gets authority by citing. So always give citations. Future researchers can locate the sources if publication is accurately presented with all the sources cited properly. So this is academic integrity, which should be followed. It saves you from unethical behavior. And if plagiarism is detected, your reputation is at risk. So all these things need to be considered. So our overall responsibility is awareness about what is plagiarism, guard against the temptation to use other person's information completely as it is. Editors also should be more proactive by giving instructions and sessions even to the writers. And you should follow the journal guidelines and use multiple available resources and give credit to them. Now, there are two famous historians, Stephen Ambrose and Doris Goodwin. Stephen Ambrose was one story, and Doris Goodwin, the book was The Fitzgeralds and the Kennedys. And this person had to say sorry because 50 passages were lifted from this book. So it was objected upon. And regarding the first, that is Doris Goodwin, that is Stephen Ambrose's book. His book was The Wild Blue, and it was copied. Many of those passages were copied from Thomas Childer's Wings of Morning, 1995 publication. It was about World War II bomber pilots. So they were pointed out, and he had to say sorry. He was charged for this. The things were retracted. So, and the Goodwin, the second case, he had to leave his TV. He was working in TV. He had to leave his position because he was also Pulitzer Prize judge. So all the positions he had to leave because of these cases. Now, how to avoid, in short, avoid plagiarism. First, know about plagiarism. Now, such workshops are there. Write in your own words as far as possible, wherever possible. Give references and citations. To reduce plagiarism, there is ICQP formula. I stands for identification. You try, if 6 words are matching all together, you are copying it. Citations, try and give citations. C. Q, give quotations. Citation is you cite. Q is you give actual quotations. P is paraphrase. And there is a paraphrasing software also. Nowadays, you can use software like Grammarly for good spelling. Now, quillbolt.com is a software for paraphrasing. So you can use that for avoiding. Now, this is my last request. Libraries and librarians play a very important role in prevention of publication misconduct because they are knowledgeable in handling databases, anti-plagiarism software, referencing, and citation tools. They can conduct training sessions on Mendeley and Zotero. They are information specialists. So try and go to them. They are the best people to guide you. Then they conduct information literacy programs and give information on good practices in research. They should be followed. And they sensitize users on plagiarism. So always use library. Take the advice of the librarians in addition to the advice of the guide. That is what, with this advice, I conclude my presentation. Thank you very much. If you have any questions.
Thank you so much, madam.
Thank you. Thank you so much, ma'am, for the wonderful presentation. And after listening to you, we feel that though the research is the combination of ethics, governance and aspirations, and as well as you can say somewhere the ambition of each and every person who wants to conduct the research. So thank you so much. We open the forum for the question and the answers. We'll be taking few of the questions. So you can put up in the chat box or you can unmute yourself and ask the questions. Any one of you with the questions? I'll just check it out the chat box. Anyone, any question? Yeah. I hope everyone, maybe everyone has understood everything, and if they have any kind of a doubt, so we will definitely reach to you for your advices. Thank you so much, ma'am, for being the part of this wonderful session.
Thank you. If there are any questions, you can give in chat, if you want.
Yeah.
Because I can't hear you. They can be given in chat.
Yeah.
Thank you very much. Shall I leave now?
Okay, but we request you, ma'am, to be the part of the second session also, if possible. Yeah. Thank you so much, madam. Thank you. Yeah.
Madam, just wait for. Sorry, madam. Pradnya here. If wait for the further session. Otherwise, Jharna, madam, you can continue for the thanks for madam. Formal.
Yes.
Yeah. With this, we are coming towards the end of the first session on the plagiarism, and we thank Dr. Sushma Podwal ma'am as our guest speaker to be the part of it and sharing the knowledge. I thank all the VPMs, Joshi Bedekar College, principal ma'am, vice principals, and all the teachers for being the part of the first session. Now, I request you to be also the part of the second session, which will enhance your knowledge towards IPR. So I request Praful sir to continue with the second session. Over to you, sir.
Thank you so much, Jharna madam. Thank you so much. Dr. Sushma Podwal madam, your presence and wise words help magnify our cause in the best possible way. So we really thank you for engaging session number 1. Now with the concluded with the session 1, and we are about to start with the session 2. And the resource person for the session 2, Dr. Suvarna Nilak madam, she has already joined. I welcome madam on behalf of the IQAC of Joshi Bedekar College, and request Supriya madam to introduce her.
Hello, good morning to all. I'll briefly explain our today's guest speaker, Dr. Suvarna Nilak madam. Am I audible, sir?
Yes, madam. Yes, go ahead.
Madam has pursued her PhD from Savitribai Phule Pune University in the year 2016, and currently she is a PhD guide. Madam has 15 years of teaching experience. Her areas of interest are intellectual property rights, environmental law, administrative law, media law, and so on. About her publications, Madam has presented papers at various national and international level then authored and co-authored many papers. She has chaired various sessions in seminar. Madam is the convener in various national seminars. She is an IQAC coordinator, and important point to mention over here, Madam has designed and conducted a certificate course in IPR law for Indian Law Society. So I welcome you, Madam, and I request you to guide our students on the topic of IPR.
Yes, thank you. Thank you so much, Supriya Madam. Before Suvarna Madam start with her the session, I definitely request all the participants to turn on their cameras again for the photograph of second session. Thank you so much. Bhakti Madam, please do the needful. Bhakti Madam, Mahesh Dudbate sir, Supriya Madam, and Avinash Wagmare.
Yes, sir.
Please.
Yes. It is done, sir.
Okay. Thank you so much, Bhakti Madam. Thank you so much. Now I request Dr. Suvarna Nilak Madam to start with the session. Thank you so much, Madam.
Good morning, everyone, and thank you very much for inviting me here to be a part of this workshop on IPR. And so the topic which is given to me is the recent judicial trends in IPR, with specific reference to copyright and trademark law. So the previous speaker has extensively dealt with the plagiarism and how and why we should avoid the plagiarism and how it is affecting the academic fraternity at large and how it is affecting the quality of research also. So I'll take up from here. What I'll do, I will briefly discuss elements of IPR before I go to the how the judiciary has dealt with the issues of intellectual property rights in recent times, and I'll be referring to some old cases also. So just let me start my presentation. Okay. So to begin with, what is intellectual property? Ma'am was talking about the plagiarism, and I just said how it is affecting the academic fraternity, why it is affecting the quality of research and all. Because there, what we do, we end up copying someone else's work. We end up encroaching upon someone else's intellectual work. So this is nothing but the intellectual property which is created by a person by using his intellectual capacity. So every person has different intellectual capacity. Every person has different thought process, and the outcome of the same is protected by intellectual properties. Now, intellectual property is nothing but a property which is created with intellects, like it could be in terms of inventions, books, paintings, songs, symbols, names, images, or designs, which are used in the business. So the legal rights which are conferred on these properties are called as intellectual property rights. Before we go into the details of IPRs, we need to keep in mind two things about the intellectual property rights, that they are territorial in nature. And secondly, the IPRs are protected for a limited period of time except the trademark law. So what is mean by they are territorial in nature? Because if the intellectual properties are created in India, the protection of Indian laws will be available only within the territory of India and not beyond that. And it is limited right, because if when you look at the duration of a patent, it is for 20 years. When you look at the copyright ka duration, which previous author also mentioned, previous presenter also mentioned, that it is during the lifetime plus 60 years. Obviously, it depends upon the kind of work which you are seeking protection for. So the IPRs are for a limited period of time. Now, why IPs are granted? IPs are granted for two reasons. That is, IPs protect the social interest and IPs protect the individual interest. Now, individual interest is protected by IP by conferring a monopoly. by conferring a monopoly. So suppose when I write a book, I have a copyright over the book, and I'm the exclusive owner of the book. Exclusive owner, not in terms of physical copies, but in terms of the intellectual property of copyright. So I have the exclusive right to use the book. I have exclusive right to own the book, which necessarily comes with the commercial aspects of the same. So what I can do with the book, I can allow someone to write, go for translation of the work, adaptation of the book may be possible. Someone who is interested, he can make a movie on the work, and that is how I can commercially exploit my work. I can commercially exploit my right. So when I'm going for commercial exploitation, that gives me some monetary value, some monetary returns, and that is something individual interest which is protected by the intellectual property. That is same for patent, that is same for the trademark also. Now, when you look at the social interest aspect of the IPRs, the social interest aspect is something like who is benefited by the IPRs. It's not only the particular individual who is benefited, but the society at large is benefited by the same. How? You may say that you're talking about the commercial rights of the individual, but how it is beneficial to the society at large? Definitely it is beneficial to the society at large, because the society get the qualitative works through these incentives. So when I know that I'm entitled for copyright, I'm entitled for certain monetary benefits and all, then I'll produce more qualitative work, and ultimately the society will be benefited by the same. So when you grant a patent will give monetary right or commercial rights to one person, but the society at large will be benefited by the technology which is patented. So it's a combination, or it's a the IPRs basically protects the interest of the society as well as the interest of the individual. So what if you allow a person to encroach upon, or if you allow a person to use someone else's IP, then definitely you will deprive the creator to exercise his or her various rights with respect to the intellectual property. And that is why it is very necessary to protect the intellectual property for the interest of the society as well as for the interest of the individual. Now, there is a myth normally when it comes to IP, that it is said that IP generally protects the individual interest only. That is not the case. When you look at various provisions of the copyright law, the patent law, or the trademark law, you will see how these IPs, the Indian IP laws protect the society interest of the society also. And there are this is not the interpretation of the judiciary as such, but you have very specific provision under these legislations which talks about the protection of the social interest also. Like under the patent law, I'll give you one example from the patent law. There was a case wherein the manufacturer of a drug manufacturer, they introduced a drug in the Indian market, and that was a patented drug. The cost of the and it was used for treating the cancer patient, and the cost of the drug was like the patients who were taking this medicine, they used to spend 80,000 rupees per month for this treatment. Now, what the Indian companies did, they because the research of the foreign company was made available by the Indian Patent Office, the Indian company, they did the reverse engineering, and the generic medicine companies basically, and they came up with an alternative to the foreign company ka drug. So this is a famous case of Natco versus Bayer. So Bayer was selling the product for 80,000 rupees, and the alternative which the Indian manufacturer came up with, drug manufacturer, Indian pharmaceutical company came up with, was made available only for 8,000 rupees per month. Now you can see the difference. So how to protect, how to have a balance between the individual interest and the interest of the society. So what these cases basically put forth the conflict between these two interests. So on one hand, you have social interest, on one hand, you have individual interest. So in this case, you can see that the courts in India have very specifically talked about the public interest, social interest, and said that the patent, when it is conferred on a person, when the patent is given to a person, he is duty bound to make the patented invention, or he is duty bound to fulfill the reasonable requirements of the public. Now, what is reasonable requirement? Reasonable requirement may be with respect to quality, maybe with respect to quantity, maybe with respect to the prices of the product. So when the prices are out of reach of the public, then there's no point in protecting the monopoly of the patentee. So the Indian patent of so the intellectual property and in the first place, the Indian Patent Office gave the compulsory license. So this is how the social interest is protected. So the Indian company was allowed to produce the drug, and for that the foreign company, that is Bayer, was forced to give license. And since it is not a voluntary license, since it was given by the intervention of the Indian Patent Office, we call it as a compulsory license within the meaning of the Indian patent law. So the compulsory license was granted. So IPs are not restricted only to the individual interest, and the object of IP law is not only to protect the individual interest, but it is to protect the interest of the society also. Now, which IPRs are protected in India? It is not only the patent or the copyright or the trademark which is protected, but you can see there are total 8 IPs which are there on the screen, which are protected under the Indian laws. Now, there is one more, that is confidential information. So confidential information and trade secrets are sometimes like used interchangeably. Now you have copyright, trademark, geographical indication, design, patent, semiconductor, integrated circuit, and plant varieties. So these 7 IPRs are protected under 7 different legislations. Trade secret, as of now, we don't have a law to protect the trade secret, but definitely there are provisions of the Indian provisions of the Indian Contract Act are used to protect the trade secret in India. Same is for the confidential information. Now let me start with the copyright before I look into the judicial perspective of the same. I'll talk a little bit about the copyright in order to have more clarity on what exactly is copyright and all. Then I'll go to the case law part. So copyright is nothing but an exclusive legal right granted to creators on expression of idea. So when a person is creating a work, when a person is expressing the idea, he is given the copyright with respect to the expression of his idea. So the copyright doesn't lie in idea. Copyright is there in the expression of the idea. How I'll explain this more with the help of case once I'm done with the basic principles of the copyright. So here, like you may have a plot in mind, plot of a web series may be there in your mind. Unless you express it, there is no copyright protection. You may have a brilliant idea about some work, but unless and until it is expressed in some concrete form, there won't be any copyright protection. So the first step for getting a copyright is expression of idea. So copyright owner has the right to reproduce, translate, adapt, perform, distribute, and publicly display the work. So these are various rights which are the copyright owner has under the Indian copyright law. Whether the registration of copyright is mandatory, the answer is no. Under the Indian law, the registration of copyright is not mandatory. The moment you create the work, the moment the work comes into existence, it is entitled for protection under the Indian copyright law. So the registration of copyright is not mandatory. Registration of patent is mandatory. Registration of trademark is also not mandatory. But it is always recommended to register a copyright for better enforceability, because when the copyright is registered, you have added advantage when there is infringement of your work. Madam was making reference to instances of plagiarism. So it becomes easier when you have your copyright registered. Then you just have to prove that other person is using your work, or the other person is there is unauthorized use of your work, unauthorized use of your copyright by the other person. You don't have to prove your copyright as such there. But if it is unregistered one, then you need to prove that you are the owner of a copyright. I'm sorry. In the first place, just a second. So in the first place, you need to prove that you are the owner of a copyright, and then you can go for the infringement instance. So that is why it is always advisable, though the registration of the copyright and trademark is not mandatory, it is always advisable to go for registration of the same. Okay. So now, which works are protected under the copyright law? The copyright law basically protects 6 kinds of works. Literary works, which includes the softwares. The instances of literary works are books, essays, compilations, computer programs. The artistic works are protected, which includes drawings, paintings, logo, chart, diagrams, photographs, work of architecture, etc. The dramatic work is there, which is protected under the copyright law, which includes the screenplay, drama, musical work, which includes the musical notations. Then you have sound recording, like the sound recording, and the example could be in the form of a compact disc. Then you have cinematograph film, which includes the movies, documentaries, short films, etc. So these 6 works are protected under the copyright law. Now, apart from these 6 works, these are 6 traditional works which are entitled for protection under the Indian copyright law. In addition to that, there are 2 other works which are protected under the Indian copyright law, and they are the rights of the performers and the rights of the broadcasting organization. Now, these 6 works we are very much familiar with: artistic work, literary work, dramatic work, musical work, sound recording, cinematography. Now, you might have seen that there are choreographers in any song. Take example of the recent blockbuster or the recent release of this Telugu cinema, Pushpa. So the movie is known for the there are certain dance moves in the movie which are very popular these days. So here, the work of the choreographer is important, but at the same time, the person who is performing, who is a dancer or the artist, either it could be the hero of the movie or the heroine, actor or actresses, whosoever it is, they are performing on the performance. So their performance is actually a value addition to the work. Their performance is actually a value addition to the work, and therefore they have a certain right which is called as a performer's right. They have certain right which is called as performer's right. Now, this performer's right is added in the Indian copyright law, keeping in mind the person's contribution to the work. Now, you may say that, okay, what is the individual contribution of the person? He's just copying the steps which are given by the choreographer. He's just copying the expressions which are told by his director to do. That is not the case. The performer has his own contribution to the work. So if you ask me to act upon a particular dialogue from any particular movie, my expressions will be very, I'll just simply say the dialogue and there won't be any expressions on my face because I'm not an actor. So every person, every actor has his own, or every performer for that matter, has his own value addition to the work. So they are also entitled for the protection as a performer under the copyright law. The same is with the broadcasting organization. Now we know that India has the Indian under-19 cricket team has reached to the final of the World Cup, under-19 World Cup. So now there will be live telecast of this match on the television. So these television channels have the broadcasting right. So these are the broadcasting organizations, and they purchase these rights of the broadcasting rights are purchased by them. So they are entitled for certain protections under the copyright law. And these 2 rights, that is performers' rights and the broadcasting, the rights of the broadcasting organization, they are called as the neighboring rights under the copyright law. So they get equal protection, definitely according to the provisions of the copyright law, like all these 6 works which are protected under the Indian copyright law. Now, when you look at the works, the duration of the copyright, literary, dramatic, musical, and artistic work is entitled for protection during the lifetime of the author plus 60 years from the date of the death of the author. Anonymous and pseudonymous works is 60 years, but if the author's identity is disclosed, then during the lifetime plus 60 years. The work of public undertaking, government work, that is for 60 years. Work of international organization is again 60 years. Sound recording is again 60 years. Cinematograph film is also for a period of 60 years under the copyright law. Now, this is all about a copyright law. It's since the time is very limited, I'm not going into the details of the copyright law, but I'll be concentrating only. I'll try to explain the aspects of copyright law with the help of these cases. If you see, the first case which is listed here is R.G. Anand versus Macy's Deluxe Films Limited, Films and Others. It's a Supreme Court judgment of 1979. It is very interesting case and first case in which the idea expression dichotomy has been resolved by the Supreme Court. The Supreme Court in India has very specifically mentioned that the copyright lies only in the expression of idea, not in the idea itself. The idea, the individual idea is not entitled for protection under the Indian copyright law. On the other hand, the what is entitled for protection is the expression of the idea. Expression of the idea. Now, the R.G. Anand's cases, when you look at the facts of the case are that there was a play written by Mr. R.G. Anand, and this play was titled as Hum Hindustan. This was a very famous play. This play become like, since it was very, after the first performance, the play became very famous and it was re-performed in subsequent years. So this success, because of this success, what Mr. R.G. Anand thought was that he thought about turning this play into a film. So he thought of making a movie based on the film. Then he approached the respondent, that is Deluxe Films and others. And meanwhile, Deluxe Films will also one of their member watched this play and he was interested in making a movie on the same plot. So the Deluxe Films, and there was a meeting between R.G. Anand and Deluxe Films, and then they discussed about making a movie, and they also discussed how to go ahead about making of this particular movie. Later on, there was no communication from the respondent to the applicant. Respondent in a sense, Mr. Deluxe Films International. So they didn't revert to the applicant, and after a year or so, the applicant got information that the respondent was making a film which was titled as New Delhi, and the applicant believed that this film is nothing but an imitation of his famous play Hum Hindustan. So Hum Hindustani is a play which is written by the applicant. Deluxe Film is making a movie. The plot is same. It is based on the provincialism and all. The plot is same in both the cases. So the applicant was convinced that the film of the respondent is nothing but an imitation of his play Hum Hindustan. So he asked the respondent about the same. He inquired about the same with the respondent, and then the respondent assured the applicant that the film was not in any way a copy of his play at all. So there is no similarity, or rather the play, the Hum Hindustani is not copied or is not imitated in New Delhi, is what the assurance given by respondent to the applicant. Then the movie was produced, movie was released. And in 1956, when the movie was released, the applicant watched it. And then he was convinced that it was indeed a copy of his stage show. it was indeed a copy of a stage show. Then he filed a suit against the respondent in the court. So when the court was going into the details of this case, court made certain observations. The first and foremost being, there is no copyright in the idea. The copyright exists only in expression and definitely not in the idea. There is no copyright in idea, it is only in case of expression. Further, the court held that no doubt there are similarities between the work, the play and the movie. There is a similarity since both of them are based upon the provincialism. But these similarities are negligible. These similarities are negligible. Now you can imagine that when you are performing a play in a theater, you have a lot of restrictions. Like you have this thing, since it is a live performance on the stage, there is no much liberty with the director or as well as with the actors. On the contrary, when it is a movie, then the shooting takes place in outdoor locations. Then the duration may be longer. Plus, there will be more entertainment in the movie. I'm not talking about the quality or theater. I'm not saying at all that theaters are not entertaining or the dramas are not entertaining, but the manner in which they are produced is entirely different. And therefore, though the plot is same, the similarity is very negligible is what the court has held. And court also said that there are certain additional plots in the movie which are not there in the play at all. So the court held that there is no violation of the copyright, there is no infringement of copyright of the appellant. Takeaway of this case is that, first of all, when you make any work, when you produce any work, take example of writing a book. When you have a plot in your mind, you don't have a copyright with respect to same, unless and until that is produced in writing. That is produced in writing. Now, take example of this case, R.G. Anand versus Deluxe Films. What would have happened if R.G. Anand has handed over the script of the play to the film producer? This story would have been different, because there was not only a discussion between these two persons, but it would have been also brought before the court that he has actually handed over his script to the producer. That didn't happen here. He just explained the plot to the film ka producer. There was a discussion among them. There was they also thought about making movie and all. That is fine, but there is no copyright in the idea is what the court has held. So don't be very this thing, like when you prepare any work, be patient, give some concrete shape to the work which you are producing, and then only you publish it. So just don't keep on discussing the plots of the works with other persons. You may take the output from others, and that is fine, but unless you give some concrete shape to the work, you are not entitled for the protection of the copyright law. The moving ahead to the next case, this case is, I don't know whether you have heard about the appellant in this case, but you are very well versed with the son of the appellant in this case. This case is Krishna Kishore Singh versus Sarla A. Sarogi. In this case, appellant in this case is father of late Sushant Singh Rajput. Now, after the untimely death of Sushant Singh Rajput in 2020, there was this thing, like a few people, very specifically 3 of them, they were making films and web series on the life of the late actor. So the appellant in this case, Mr. Kishore Singh, Krishna Kishore Singh, he approached the court and he was seeking injunction against the publication and release of the films related to Sushant Singh Rajput uh, as he was his father. So here he argued before the court that the films and the series that which are titled as Nyay, the Justice, then Suicide or Murder, then Shashank, must be restrained from being released. So this is what his primary argument is, that these movies should not be released, published or communicated to the public. That is his argument. He filed the case on several grounds, which included the violation of publicity rights and privacy rights, right to fair trial, defamation, violation of Article 21 of the Constitution, and all. I'll just concentrate only on the violation of publicity right and the publicity right under the copyright law. So the facts were reviewed by the court referred to the other relevant cases, and finally the court came to a conclusion that the plaintiff, the appellant plaintiff in this case, he failed to make out a valid case for violation of celebrity or publicity rights of Sushant Singh Rajput or his family members, because the plaintiff was not aware about the content of the film. The plaintiff was not aware about the content of the film. So the content of the film is not disclosed to the plaintiff, and that is why when he is filing the case, when he is filing the suits for injunction, these suits have this thing like are fruitless, because the plaintiff is not at all aware about the content of the film or the web series. Further, the defendants were not using the Sushant Singh Rajput's image anywhere. Then there was no this thing, likeness or name was not there. Then the film and the web series also came up with appropriate disclaimers. Now, disclaimer is something which is which, if you use, it is easy to escape from the infringement of the copyright. So again, the defendant used a tool of disclaimer. They also said that we are not using the image of SSR anywhere. There is no likeness or name. We are not using his name at all. So there is no this thing, similarity, and that is why there is no infringement of the same. Further, the court also said that now you are being a celebrity, being a public figure, you are entitled for certain celebrity rights. So these or publicity rights under the copyright law. So the court held that the celebrity rights may not subsist after the death of the celebrity, and the facts which are there from the public record may be used by the defendants without any liability. Okay, so the facts of the plaintiff, facts from the life of Sushant Singh Rajput are already there in public domain, and any person can use these facts without any further liability, because these facts are a part of public record. They are available in the public domain. Now take example of Shahid Bhagat Singh. There are multiple movies on the life of Shahid Bhagat Singh, and then you cannot claim copyright as long as the life of Shahid Bhagat Singh is concerned, because it's a fact which is in the public record, and that is why you are not entitled for the copyright protection. So the similar view is adopted by the court in this case of Krishna Kishore Singh versus Sarla Sarogi, and court refused to give injunction to the plaintiff, saying that first of all, the plaintiff is not aware about the content of the movie, and secondly, the plaintiff is not aware of the defendant is taking the facts which are available in the public record. So there is no infringement, there is no such infringement of the right, any right of the plaintiff or his family. The next case is again with respect to this is a case of infringement of the copyright of a software. So here again the software was prepared which was similar to the software by the other company, and then the copyright infringement case was filed. So court basically looked into the similarity aspect and held that when the works, the court basically looked from the aspect of a person who is skilled in the art, that the software which is new, or when you are claiming protection with respect to the software, then that is available only if it is original in nature. Only if it is original in nature. So when there is a copy, then there is no scope for scope for protection under the Indian copyright law. Then the next case is John Hart Jr. and another versus Mr. Mukul Devra. In this case, the plaintiff, that is Mr. John Hart, he claims to be vested with the exclusive copyright to make a movie adaptation of the book, The White Tiger. So White Tiger was a movie which was released, I think it was again a web series, which was released in 2019 sometime. No, that was released during Corona. So it was sometime in 2020, this was released. So the plaintiff here in this case, he is claiming that he is vested with the exclusive copyright to make a movie adaptation of the book White Tiger, which is authored by Mr. Arvind Adiga by virtue of literary option or purchase agreement, which was made in 2009. So plaintiff one, that is Mr. John Hart, he was claiming to be, he has the exclusive copyright because there was an agreement between him and the author, that is Arvind Adiga, on the title with respect to the book. Then plaintiff approached the court at the 11th hour to seek an injunction restricting the release of the film White Tiger, produced by defendant number 1, to be released on the streaming platform Netflix. So this White Tiger was supposed to be released on Netflix, and on 11th hour, like just before the release, 24 hours before the release on the Netflix, the plaintiff approached the court. The plaintiff asserted that when it came to their knowledge that Netflix was in the process of making and releasing the film, a cease and desist notice was issued to the plaintiff. All the facts were analyzed by the court, and the court came to a conclusion that though you may have a copyright, but that doesn't mean that you can approach the court last minute, like 24 hours before the release. So when you are in the film fraternity, then there is every possibility that you will be aware about the making of the movies, then the release of the movies, the production houses and the plots and all. But the plaintiff didn't approach the court in time, and there was this delay was not and now the plaintiff is not able to justify the delay. So what the plaintiff said is that, plaintiff in the sense John Hart Jr. and others, they were claiming that this movie was shot by the defendants in the COVID-19 pandemic, and they were not aware about the production. This agreement or this argument of the plaintiff was not accepted by the court, and then the court held that there is every possibility that the plaintiffs were aware of the film being released on the Netflix platform from October 2019. So there is no material produced by the plaintiff by which they can justify that why they approach the court just before the release of the movie. Now, what is the takeaway of this case? Why I choose to discuss this case is that when you know that someone is using your right, someone is using your copyright, don't sit idle. If you are looking for the intervention of the court, immediately approach the court, immediately go to the court and seek the appropriate remedy. So here, whether the plaintiff has a copyright or not is a different question. Court didn't go into the scene. Court said that plaintiff has not approached the court within the reasonable time. You are approaching the court 24 hours before the release of the movie, and that is not you are supposed to do, because if you have a copyright, if you claim to have a right over the work, then you should be more vigilant and you should have closed the code within the reasonable time, and then the code refused to interfere. So if you are having any work which you want to protect, if you're looking for a protection of the copyright, either it could be it could be the musical work, sound recording and all, make sure that you're vigilant about your right. You're approaching the code within the reasonable time in order to get the appropriate remedy. Then the next case is with respect to the copyright protection with respect to the title of the movie. Now, this case is Krishika Lilla and others versus Shyam Vittal Rao Devkatta and another. This case is considered to have set a standard relating to infringement in film titles and plot lines. So this case is also very famously called as Desi Boys case. I'm sure many of us have watched this movie. So in this case, the plaintiff authored a story titled Desi Boys, and the spelling was BOYS. So the plaintiff authored a story and titled it as a Desi Boys, and he registered the synopsis with the Film Writers Association. So the synopsis of the movie was registered. Sorry, the synopsis of the story was registered with the Film Writers Association. Then he forwarded the synopsis to his acquaintances subsequently. Later on, he came across the trailer and promos of the movie titled Desi Boys. Now the spelling here is BOYZ. So he came across this movie which was titled as Desi Boys. Since he understood that he could not allege infringement over his idea because of the R.G. Anand's case, now film fraternity is well aware about the copyright protection not being available in the idea. So what he did, he was knowing that he could not allege infringement over his idea or a story under copyright law. What he did, he filed an FIR for the copyright infringement of the title Desi Boys under under the relevant provisions of IPC, CRPC, and very specifically Section 63 of the Copyright Act. Now here, the main issue before the court was whether there is a copyright in the title of a story, or whether there is whether the title of a film is entitled for a copyright protection. So whether a literary work's title on a standalone basis is a copyrighted work that is capable of being infringed under the copyright law. So the Supreme Court rejected the notion of the title of a film constituting a copyright work to begin with in order to qualify for infringement. So the Supreme Court very specifically held that no copyright in the title of the movie. No copyright can be there in the title of the movie, is what the judgment of the court is, and obviously the plaintiff was bound by the order of the court. So when you look at all these cases, there are like a few other cases also when it comes to the copyright law, which are very famous, which has gained a lot of attention, and very specifically from the either from the literary work or the cinematograph film. When you look at the judicial trend of these cases, the court sees that yes, unless you are till the time you are the original owner of the copyright, you are entitled for the protection of the copyright under the copyright law. So you have to be owner of the work. You have to be the the work must be original in order to seek protection under the copyright law, and you should be owner. Then the author is entitled for the protection, and all that is subsequently will be there. But the first essential element of the copyright work is it should be original in nature. Now we don't look into the quality aspect of the copyright law. That is very unfortunate thing. So whatever this thing, substandard thing you write, that is entitled for copyright protection till it is original. So when it is original, it is entitled for protection. If it is not original, it is not entitled for the protection under the copyright law. So these are some important cases of copyright which I thought of discussing with you. Now I'll move to the trademark. I'll take all the questions in the end of the session instead of like taking the questions on the copyright immediately. So the trademark is trademark is a name, word, sound, or number, numerals, symbol, or drawing, or their combination that is protected under the trademark law. So if you see on the screen, I have shared two famous trademark. One is Rolls-Royce ka, and the other one is BMW ka trademark. So what is the trademark importance? Trademark gives the identification. Trademark is nothing but it gives the identity to the product. It is an identity of the, it gives identity to the goods or the services which are offered by the company or the individual. So as I told you previously, the registration of the trademark is voluntary, is optional. But if it is registered, then after every 10 years, you have to go for renewal of the same, and there will be perpetually it can be renewed. Now, what is the, when you look at the origin of the trademark law, that started with the when the import of the goods was started through the ships. Import and export started through the ships. So the traders who used to send their products, who used to send their goods through ships, in order to identify their goods from the goods of other traders, they used to put some marks, some labels. And that is how the concept of trademark is evolved. And over the period of time, this trademark become very important. Trademark of any good or any product become very important. So when we purchase any product, we look for the mark, we look for the origin of the product. Now, origin in the sense, who is the manufacturer of the product? So trademark is nothing but trademark taxes to the manufacturer of the product. So who is the manufacturer? Okay, fine. I'm purchasing a car. If it is Hyundai, I know who is the manufacturer. I know about the reputation which they have in the market. I know about their technology. So I'm assured as long as certain features of the product are considered. The same is with phone. When we purchase phone, we go by the mark, the trademark. If it is iPhone, we go by the mark. We go by the trademark. So the trademark again is a value addition to the product. So when the students of commerce will be able to understand this better than me, that when there is a this thing, when the assets of any company are calculated, then the major contribution to these assets is by the reputation, or the reputation, or by the value addition comes from the trademark. So you will be surprised to know that the trademark value is the trademark adds more value to the company than any other assets of the company. So having a trademark is very important, and that is why it is included in the as one of the intellectual property of the trademark. In the as very as an essential intellectual property. Okay, now which words can be used as a trademark? What are the essentials of a trademark? Like there are certain features which you should keep in mind when you are using a trademark against your goods or services. That it should be unique, like for example, Doordarshan, then it should be distinctive in nature, then it should be non-dictionary words, it should be invented word. Then the custom designs or symbols, devices, and they should be non-descriptive. So these are the advisable or do's as long as you're choosing a trademark for your goods or services is concerned. What you should avoid is avoid the adjectives like efficient, like brilliant. Now I'll come to this brilliant wala thing in some time again. Then names of the person or the places should be avoided. Then the words which are obscene in nature should be avoided to use as a trademark. Then symbols, the religious or constitutional belief should be avoided when you are choosing a trademark. Then common shapes should be avoided when you are choosing a trademark. Okay. Now, how to indicate to a trademark? These are three things, three symbols which you may come across against any trademark. When it is R in a circle, that is your registered trademark. When this could be used against the services as well as against the goods. Okay, R in a circle is a registered trademark which can be used by any person against his goods or services when he completes the registration under the trademark law. TM is unregistered trademark with respect to goods. But when you use TM, either the registration process is pending before the registrar of a trademark, or when you use this symbol against your product, then that shows your intention to use it as a trademark. So two possibilities are there. When you see this TM against any trademark, that shows the person's intention to use it as a trademark, or the person has already applied for registration of a trademark and his registration application is pending before the registrar. The same is with respect to SM. SM is used against the services which are being provided. So when the symbol is there, that shows that a person has either his application for registration of service mark is pending, or he is basically willing or he is intending to use it as a trademark against the products or against the services, not product. Now, I've just given some instances of this thing like infringement, and you need to identify which exactly is the infringement here. So translating a book saying like the Harry Potter series in the local language, whether it amounts to infringement, making a copy of software, whether it amounts to infringement, downloading the movie, whether it amounts to infringement, and all. Okay. Now, when you talk about these trademarks, I have a couple of cases to discuss with you, and you can participate in the chat box. You can give your answers in the chat box about your opinion. Now, okay, coming to this case. Okay, have you heard about this coffee ka brand?
Yes, ma'am.
How many of you have had the coffee from this brand?
Not had it, but heard about it.
Have you seen the logo?
Yes, ma'am.
So did you think the logo which is shared on the screen is correct one?
Like I haven't seen it very carefully, but it is somewhat similar to Starbucks, I feel.
But is it the Starbucks ka logo which I'm sharing with you?
No, this is the difference.
See, this is something different, isn't it? This is not something which is a Starbucks, definitely, isn't it? But
Sardar Baksh.
yeah, it is Sardar Baksh.
Yes.
Now, if a person sees this, let me go ahead. This is the Sardar Baksh ka coffee ka outlet. It became very famous in Delhi, like 6 years before. If you see, it is established in 2015. Starbucks is quite old. Just a second. Yeah. So this is Starbucks coffee outlet, which is quite a posh outlet. Sardar Baksh Coffee was also a posh outlet, but they had their other appearances also like this. So small stalls also they came up with. Now these are the two logos. Starbucks Coffee and Sardar Baksh Coffee and Company Limited. Do you think they are similar in nature? I won't say same, but are they similar?
Yes, ma'am, they are similar.
They are similar. So they are similar for us also. So consider a person who is not aware about these brands at all. For him, it will be very difficult to understand the difference between these two. Now, this is a very famous case of Starbucks Corporation versus Sardar Baksh Coffee and Company of 2018. Now, I'll explain the facts of the case in detail. In 2001, the Starbucks registered their trademark in India with a word mark pronounced as Starbucks, along with the logo visualizing a crown medal with a long hair. So this is the Starbucks ka logo, which is registered, and you can see the R in circle here. And whereas the defendant, he was a local vendor, he initiated his business in 2015 with a name called Sardar Baksh Coffee and Company. So slowly and steadily, the defendant earned fame, and as a result, in May 2018, the defendant formed a private limited company with the name Sardar Baksh Private Limited. So when you look at these logo, you can see the similarity. Now, this is the Sardar Baksh ka logo, and they formed a company in the year 2018 by the name Sardar Baksh Private Limited. So everything was going smooth for the defendant. And then it was brought to the notice, the defendant's presence and the logo was brought to the notice of the plaintiff. So plaintiff, that is Starbucks Corporation, filed a suit against the Sardar Baksh in Delhi. And the ground of the case was that the logo of the Sardar Baksh is deceptively similar to the logo of the Starbucks. And that is to deceit. It is a deceit. It is a fraud. The argument of fraud was not there, but it's a deceit. So there is a deceptive similarity between these two logos, is what the argument of the Starbucks was before the court. Now, when the court was looking into the case, the first and foremost aspect which was noted by the court was the product both the companies were dealing with, as it is an unwritten yet significant rule that if companies to the suit is dealing with a different product, then having a name almost identical still won't be considered as an infringement. So here in this case, the product was identical. So there, that is so the infringement case might be there. So if both the companies are dealing with different products, then there may not have been a case of infringement. So here in this case, the product was identical, which took the proceeding to the next step. So the court observed that the name used by defendant was too large. Then to a large extent, it was confusing. So to a large extent, the defendant's logo was confusing. And as a consequence of the same, the court ordered the defendant to change the logo. So the court took into consideration the element of similarity between these two logos, and the defendant was asked to change the logo to Sardarji Baksh Coffee and Company, from Sardar Baksh Coffee and Company. So if you visit Delhi sometimes, then you will see that this is quite a famous outlet of coffee. These outlets you can see in many parts of Delhi. So the respondent was asked to change the logo from Sardar Baksh Coffee to Sardarji Baksh Coffee by the court. The defendant now is operating with the name uttered as Sardarji Baksh Coffee and Company in and around Delhi. Moving ahead to the next case, this is a very famous dispute between Coca-Cola Company versus Bisleri India Bisleri International Private Limited. There is one more case of Coca-Cola versus Pepsi, but that I'll come to it like after this case we are done with this case. So in this case, the Coca-Cola Company and Bisleri International Private Limited. I'm sure you are aware about all these three words: Coca-Cola, Maaza, Bisleri. So Maaza was first introduced in India by Bisleri. Maaza, this drink and the name, the drink with the same name was introduced in India by Bisleri International Private Limited. And Bisleri is famous for providing mineral water. But later on, Coca-Cola approached Bisleri and acquired the rights attached to the product Maaza. So these rights included, but they were not restricted to the right to formulate and intellectual property rights. Both the companies signed a deed for transferring the rights, which included acquisition of goodwill, then transfer of the IPR, no use and non-compete clause. So along with these clauses, the transfer did happen. But in 2008, the Bisleri applied for trademark registration of Maaza in Turkey. And on the same trademark, they started exporting their product named Maaza from India to Turkey. So they used to they started manufacturing in India, but their products were not sold in India. They applied for registration of Maaza in Turkey, and they started the export of their product from India to Turkey. When the Coca-Cola got to know about the same, they filed a case of trademark infringement in Delhi High Court. And then Delhi High Court looked into the case, and later on, the court ordered the defendant, that is Bisleri International, to stop from using the trademark Maaza. Now here,
Teachers are requested to mute themselves.
thank you, sir. So when you look at this case, in the beginning, I told you that trademark is territorial in nature. This Bisleri company has applied for registration not in India but in Turkey, and they were manufacturing their products in India. So the court issued the order of injunction against using the product Maaza for any products which were produced by Bisleri. So whether the products are made available in India or not, that was immaterial. But the court held that you can't use this trademark anymore, since there is an agreement of transfer of IPR between Coca-Cola and Bisleri. Now, moving to the next case, that is Pepsi company versus Hindustan Coca-Cola Limited. Now, I'm sure all of you must have observed that there is always a advertisement war going on between Pepsi and Coca-Cola. Just after this webinar, you can search on the Google for the banned advertisement banned advertisement of Coca-Cola and Pepsi. Then you will see that how they try to like defame each other's brand through the advertisements. So this is one of the example which reached to the court in 2003. In this case, the Hindustan Coca-Cola Limited, which is now it is Coca-Cola Limited. So they publicly exhibited an advertisement in which they asked a child a question about his favorite drink. This advertisement is available on the YouTube. You can just watch this advertisement later. I'll just explain what is there in the advertisement. So the Coca-Cola publicly exhibited an advertisement, and in this advertisement, they asked a child a question about his favorite drink. And the child was provided with two choices. The first being Thumbs Up, a product of Coca-Cola, and the option was labeled as Puppy with the business logo, which is very similar to the PepsiCo logo. Then, in this ad, the child was asked to test both the brands, but before testing them, the child was asked to provide the name of his current favorite drink. Responding to the same, the child uttered the word Pepsi, which was muted in the advertisement. But you can easily guess that through the lip syncing of the child that he is uttering Pepsi. Later on, the Blind testing is conducted with a child where the child, after testing both the brands, opted for the respondent's drink and made few defamatory comments against the drink labeled as puppy, though it was pronounced as puppy, but it was depicted as Pepsi. So here the defamatory comments which were used by the child included like bacho wale drink, then wrong choice baby, etc. or ye dil mange no more. So you may realize that these are the this thing, some popular this thing words or slogans which are used by Pepsi in order to advertise their product. So this went to the court, and the court asked the respondent to stop communicating this advertisement. So the court issued the injunction, and the defendant was stopped from, the plaintiff in this case, that is PepsiCo, the defendant, that is Hindustan Coca-Cola Limited, was asked to prohibit this advertisement on any television. Now, when you look at this case, the court has looked into the intent of the commercial, that is advertisement, manner of commercial, the storyline of the commercial, and the message which the person sought to convey through this commercial. So, ye dil mange more or wrong choice maybe are the words which are used in order to defame the trademark of the Pepsi. And this argument of the Pepsi was accepted by the court. Okay, moving ahead to the next case, that is okay. Before I go to the facts of the case, what is this? Could you please tell me?
So, ma'am, it is Louis Vuitton's symbol signature, like logo on back print, but they have then printed it on some food carton, I suppose.
Yes. So, this is a case of Louis Vuitton versus Louis Vuitton Dark. Now, this case is an example of where there is the war is not limited only for the same business domain, but it is across the businesses. So here the Louis Vuitton, that is the second one, is a South Korean fried chicken restaurant, and they started using this trademark. Now, if you see, there is quite a similarity between these marks. So the Louis Vuitton Dark, which is a South Korean fried chicken restaurant, they lost the battle against the clothing designer Louis Vuitton. The court here decided this case in favor of the designer and held that the restaurant's name is too similar to the brand name of the plaintiff. Also, the logo and packaging of the restaurant, were resembling very much to the designer's iconic imagery, is what the court observation and the injunction was granted. Later on, the respondent started using the word Louis Vuitton Dark, which is also for which they again paid a heavy penalty for violating the order of the court. Okay. Then the next case is from here. This is Zara Food versus Zara Fashion. It's a very famous dispute from Delhi. Again, this is one of those disputes wherein you can see a fight between food industry and the fashion industry for the brand name. So Zara, the conflict is for the brand name, or this is for the ownership of a brand name, that is Zara. So Zara is a renowned fashion brand which is having major operations across the world, including India. And they found that there was a restaurant operating in Delhi under the same name. So you can see this in the second picture. That is Zara, the Tapas Bar, and the restaurant. So it is, when you look at these two brands, these two logos, it is highly possible that any consumer would confuse one for another, and taking into consideration, and there is a possibility that we'll presume that Zara, the restaurant, is started by the famous fashion brand Zara. So the court, Delhi High Court, held that Zara had a presence in India since 2010, when it opened its first store through a joint venture, and has also applied for a few trademarks in India. The restaurant, because of this, the restaurant was forced to change its name, and now it is operating in Delhi under the name of Tapas Bar. So they have removed the name Zara from their brand. Now they operate only with the word Tapas. Then there is one more case. There are a couple of other cases. If you see, that is Lakme Limited versus Meso Subhash Trading. Herein the dispute was with respect to Lakme and Like Me. The court held that they are similar. Then there is a case of SM Dichem Limited versus Cadbury India Limited. The dispute is with respect to the trademark Picnic and Picnic. You can see the similarity between them, though they are not visually similar. Phonetic similarity is definitely there. Then Big Tree Entertainment versus Brainseed Sportainment, BookMy and BookMy Show. Then you have a case of Cadila Healthcare Limited versus Cadila Pharmaceutical Limited, which is a case of pharmaceutical companies wherein they fought for the name of Falsi Tab and Falsi Go being the similar names. Now, when you look at all these cases, you can see that court has adopted different standards. Few of them are like whether the words are, whether there is a visual similarity or whether there is a phonetic similarity. Apart from that, in some cases, the court has also looked into very important aspect, which you can see from the last case, that is Cadila Healthcare Limited's case, that when it comes to medicines, the courts are very strict, because in Cadilla's case, court has held that the medicinal products, majority of the medicines in India are available over the counter, and there you don't need to, though the prescription is required, but these medicines are available over the counter, and that creates confusion. So in order to protect the brand name, we should go by the strictly implement the deceptive similarity principle, and when there is a deceptive similarity, then the person should not be allowed to use the name. So these are the cases of deceptive similarity which has been which the court has held that the trademark, the object of the trademark law is to protect the reputation of the person, as well as the trademark law, as well as the trademark basically is a link between the purchaser, end consumer, and the manufacturer. So trademark takes the consumer to the manufacturer. So if there is a deceptive similarity, then the consumer will not be able to reach to the real manufacturer. And therefore, these instances should not be these trademarks should not be allowed to be used. So the word deceptive similarity itself is kind of self-explanatory. There is deception in the minds of people. There will be confusion in the minds of people as long as the trademarks are concerned. So when you visit any departmental store, you will see that they are keeping the same products, the similar products along with each other. So when you look at the Harpika bottle in DMart, then you will see, when you visit DMart next time, you can see that they'll keep the other products, other similar products with a different manufacturer, but the packaging will be very same to Harpic, and they'll keep it together. So there'll be confusion in the minds of the public. So in order to avoid this, the only remedy is the strict implementation of the trademark law. But like copyright, here also you need to be vigilant about your rights, and you have to approach the court in the reasonable time. Now, before I conclude, how we can contribute to the intellectual property, whether it is copyright, whether it is trademark, whether it is patent, whether it is design, I always tell that don't copy, don't imitate, produce your original work, and insist for the original products. So don't buy fake products. I'm not promoting any brand or something like that, but why you should not buy fake products? Because there you end up in compromising with the quality of the product. You need to be innovative, think outside the box. Unless you think outside the box, you cannot produce any intellectual property. So with this, I stop here. I would like to take any questions. If there are any questions, I would like to take that now. Yeah.
Thank you so much, madam. You are clear the stirring and clear the more informative talk, definitely clear. Guide us on the clear the topic about it to you recent judicial trends in copyright and trademark. Madam, you clear the effectively and clear the meticulously elaborated and analyzes clear the current cases for our understanding and made us clear, easy to understand clear the judicial trends in the clear the copyright and clear the trademarks. Now I clear the request teachers, if you're having any questions, you can drop them in the chat box so we can clear the read it out for clear the madam. Otherwise, madam can also, otherwise you can unmute and you can ask your questions if you're having any in your mind. Meanwhile, let me make announcement regarding feedback link. Feedback link for teachers as well as clear the students will be shared. Your feedback is indispensable, inevitable. So it is clear the important for each and every clear the participant to fill this clear the feedback link. Otherwise, to record their feedback, it will be feedback link will be open till 3 p.m. So clear before 3 p.m. you have to submit your feedback. Yes, teachers, any questions? If no, Pradnya madam, shall we go ahead?
Yes, sir, we can.
Okay. Thank you so much. Now, I request Professor Bhakti Gaikwad to propose vote of thanks.
Yes, sir. So a very warm afternoon to one and all present here on virtual platform. I, Bhakti Gaikwad, on behalf of VPM Joshi Pedekar College Autonomous, stand before to you, propose the vote of thanks. Here I would like to quote William Author. He says that feeling gratitude and not expressing it is like wrapping a present and not giving it. With these words, I express my gratitude towards our distinguished speaker Suvarna Nilak ma'am, and also speaker of session 1, Sushma Paudwal madam, for the explanation, legal insights and rights and wrongs of IPR. Thank you, Suvarna Nilak madam. I express my sincere thanks to our management of our college, especially our chairman, Dr. Vijay Pedekar sir, for being the lighthouse to the entire Joshi Pedekar team, it gives me immense pleasure to place on record our deep gratitude towards our principal, Madam Dr. Suchitra Naik, for being constant source of inspiration with her unwavering support in organizing such events. I also thank our vice principals, Dr. Priyambada Tokekar Madam, Dr. Mahesh Patel sir, and Dr. Subhash Shinde sir. I thank all the HOD coordinators and teachers for making this session a great success. I also thank Mahesh Dudbate sir and Supriya More Madam for the technical support. I express my gratitude to Dr. Pradnya Raja Bahadur Madam, IQSC coordinator, for bringing such eminent speakers to us. Last but not least, I thank all our students who all attended this program through YouTube live session. So thank you one and all.
Thank you so much, Professor Bhakti Gaikwad. Now, as per the tradition of our college, we are going to conclude this program with the Pasaidan. So I request Mr. Mahesh Dudbate to do the needful and play the audio recorded and sung by our TYBFS office student, Ms. Prajakta Shendri.
आता विश्वात्मके देवे येने वाग्यज्ञे तोषावे तोषो निमजडावे पसायदारहे जे खळांची व्यंकटी सांडो तया सत्कर्मी रति वाढो भूतान परस्परे पडो मैत्र जीवाचे दुरिताचे तिमिर जावो विश्वस्वधर्म सूर्य पाहो जो जे वांछील तो तेला हो प्राणी जात वर्षत सकळ मंडळी ईश्वर निष्ठांची मांदियाळी अनवर्त भूमंडळी भेटतो भूता चला कल्पतरूचे आरव चेतना चिंतामणीचे गाव बोलते जे अर्णव पियुषाचे चंद्रमे जे अलाच्छन मार्तंड जे तापहीन ते सर्वाही सदा सज्जन सोय रे होतो किंबहुना सर्वसुखी पूर्ण होनी तिन्ही लोके भजी जो आदि पुरुषी अखंडित आणि ग्रंथोपजीवी विशेषी लोके दृष्टा दृष्ट विजय हो आवे जी येथ म्हणे श्री विश्वेश्वरा हो हा होईल दान पसा
Thank you so much, everyone. Again, gentle reminder for everyone to record their feedback with the given link. Thank you so much.
Thank you.
Thank you, everyone.
Thank you, Suvarna madam.
Thank you, Suvarna madam, Pradnya madam, Bhakti
Thank you, sir.
madam,
Thank you, ma'am.
Supriya madam,
Thank you all.
all play the teachers. Thank you
Joshi
so much.
Bedekar teacher.